Welcome back to our commonhold series. I'm Christabel Smales. I'm a knowledge lawyer in the commercial real estate team here at Cripps. And today we're going to be discussing the practical implications of commonhold for developers. Well, the reforms, as we've already talked about, focus on residential leasehold flats, but the legislation needs to adequately address the complexities of mixed-use developments as part of that to ensure that commonhold provides a robust and flexible enough structure for developers, owners and funders alike. Developers, as a general rule, don't seek long-term ownership and management roles in developments, and regardless of tenure structure, and exit strategy is absolutely key. So there is an argument that commonhold may not have a significant impact. However, as we'll go on to see, the nature of the proposed new regime does require extremely careful treatment of development rights, and in particular, sensitivity to the management needs of mixed-use and multi-tenure schemes. So Anna, just coming back to you, what do you see as the biggest headline change for developers?
I mean, I think it has to be the potential ban on selling new leasehold flats. I mean, that is as radical an overhaul of the real estate tenure that I've encountered in my 20 years of practice. So I think that must be the biggest criteria for developers, or the biggest consideration. And if we pause and just think about what that will apply to, I mean, all types of developments, not just pure new build developments, obviously new blocks of flats. It could be a conversion of a house, typical terrace that's divided into two flats. It could be conversion of commercial premises. Obviously it's far easier now, isn't it, to convert to residential. Purpose-built blocks of flats, so student accommodation will be impacted as well. And then, of course, refurbished residential blocks, they will likewise be brought within the ban. There are certain permitted leases, as Philip alluded to earlier, but they're pretty narrow. And I agree with you that it will make complexity an even bigger consideration.
What does that actually mean in practice? What are the concerns?
Well, it is with one caveat, the gradual phasing out of leasehold. The government has been absolutely clear on its agenda in that regard. Leasehold is the terminology deployed regularly in parliamentary debate, and there is a clear desire to phase out leasehold. That will be the ultimate effect. There is an exception there, which is one of the criteria in order to become common holders, that you first need to enfranchise your building. And so for those buildings that don't qualify, perhaps because there's too much commercial, and therefore it doesn't fall within the 1993 Act, which is the collective enfranchisement rights conferred on leaseholders, then they will be the outliers. And as an aside, Chrissy, I have concerns that will merely embed the depressed value and the two-tier system that seems to have sprung up on the back of some of the reforms we've seen to date. But that's a side point.
How will this big change affect funding and viability of schemes?
Yeah, well, it's a challenge, isn't it? I mean, I think it's really ingrained in our culture as a real estate sector. The reliable income stream that comes from ground rent investment has been in place for many decades. Many people are heavily invested in that sector. I think it will have an impact. I think the income stream is going to be removed. That's where a significant amount of value is perceived to be, and indeed is. And also the loss of reversionary interests. I mean, the main component of a landlord's asset class, if you like, is that reversionary value, but also the income stream from ground rent. In terms of practical suggestions, of course, if you've got an existing pipeline of work, you would need to look at that to make sure that it remains viable in the context of the proposed reforms. The timing for implementation of which remains to be clarified, but nonetheless, we have been put on notice this is coming down the line. And also see whether or not there is an affordability piece there, whether or not, because of the drastic change in the income stream, ultimately the development is one which remains on track and viable.
And another key piece for developers is looking at mixed-use schemes. Philip, how do you think commonhold structures will work in the context of a mixed-use?
Well, I think inevitably mixed-use schemes are going to be the test of the system, and really it will be the make or break as to whether commonhold works or not. Because if it doesn't work, then mixed-use development will stop, and this will bring the entire sector to a juddering halt. It's intended to work, clearly. It's been recognised under the current law that commonhold is ill-equipped for either multi-block development or mixed-use development. And the reason for that is principally because you couldn't divide it up in any way. You could only have everyone voting on everything, and importantly, you could only have one service charge pool, one commonhold assessment for everybody. So you couldn't, for instance, say, well, the commercial units who don't use the lift don't have to contribute to the lift. And that very simple flaw effectively prevented any chance of commonhold being adopted beyond the 20 small blocks who have adopted the system in the 20 years since the 2002 Act came into force. And what the new bill will do is address this by creating a concept of sections. And a section is what you might think it is, which is you'll be able to divide up the commonhold development to allow different governance for different parts, most obviously between residential and commercial, but it could also be between different residential blocks sitting on a common estate. And the way it's going to work is that where there is a section and there's something which only affects that section, then only the unit holders in that section can vote on that particular matter. There'll also be mandatory separate costs pools, which will ensure that only those who benefit from a particular service within a section are responsible for paying towards it. So that simple but very, very important change means that you can, in effect, create the kinds of structure which you have in modern mixed-use leasehold developments, where, for example, you have an estate service charge and a series of block service charges. You'll be able to replicate that by using sections and different costs pools. And the way it will work, where will you find this information? Well, the information about any sections will be set out in the commonhold community statement. What we don't know is exactly what will or will not be permitted to be a section, because there are going to be regulations which set out the criteria for establishing different kinds of section, with a fallback for applications to the first tier tribunal, or the LVT in Wales, for the tribunal to approve of a section being created following an application.
Can sections only be created at the outset of a development?
Well, that is a very good question, and one can't give a complete answer without knowing what the regulations are going to say. But what one can say is that a section can only be created for, quotes, good reason. It's hard to see how the new scheme will work if developers can't pre-plan the sections which they're going to put in place. So I think the answer is yes, developers will be able to create the sections when they set up the commonhold development. It is also possible, and the Act permits this, the bill, I should say, permits this. It is possible to create sections later if certain voting thresholds are met.
And what does the introduction of these sections mean in practice, do you think?
Well, the plus side, as I've said, is that it will be possible to create the necessary differentiation between residential and commercial units in a mixed-use scheme, or between different blocks in a common estate. That's the plus side. It gives developers flexibility. It will allow the current types of complicated but very popular developments to continue to be created. On the other hand, it is going to create a lot of work in the structuring exercise, drafting the development documents, making sure that the commonhold community statement does actually, from the beginning, do what it needs to do, because it can be difficult to change the provisions in the commonhold community statement if it turns out that a mistake has been made.
And I think another key concern for developers is going to be to ensure that they have adequate rights to continue developing land or site after units in the development have been sold. Now, under the 2002 commonhold regime, so commonhold Mark I, developers are able to take development rights to build a commonhold site, but it's so long as they are designed to permit or facilitate one of the specific development activities set out in what is essentially an exhaustive list in the schedule to that 2002 Act. Now, the Law Commission have recognised that this approach is too restrictive compared to that in leasehold developments. How will developers' control work during proposed development in this new bill?
Well, the new bill goes to the opposite extreme. The new bill gets rid of the list completely. And the new bill will allow a developer to take any rights they need to complete the development. And completing the development includes marketing the commonhold units. Not only that, it also says that developers will be able to make provision in the commonhold community statement requiring cooperation from those living in the commonhold. So if you've got two phases, then the commonhold community statement will allow the reservation of any rights you need to create phase 2, and will also require everybody who lives in phase 1 to cooperate with the developer in creating phase 2. Now, you would have found this sort of thing in a well-drawn lease in a phased development, but that didn't exist under the previous regime, and it's now going to be in the new regime.
Apart from some very tricky drafting, which I think we're going to all have to get our heads around, what do you think? Obviously, what developers are going to do is to reserve everything under the sun, so we have to provide drafting for that. How do you think this will play out, and what ideas do you think we'll see?
The intention of the bill is clearly to get rid of the list. So although it remains to be seen what regulations say, it occurs to me that a well-drawn development right will be very short and very wide. It will simply say the developer, putting it in layman's terms, the developer can do literally anything it wants to complete the development, subject to the protections for unit holders which are in the bill, because there are protections. So the right has to be for the purposes of, quote, development business, which is defined as completion of the commonhold site and the marketing and sale of units. But it doesn't seem to me there's anything wrong with drafting it in a way which simply says that the developer has any right which is for the purpose of development business, because it will then mean, and this is the point I'm going to come on to, that they won't be able to do something which isn't for the purposes of development business. Because the bill introduces safeguards, and these are going to be set out in regulations, but as you might expect, they will protect unit holders from development rights being exercised in a way which interferes unreasonably with their rights, i.e. interferes with the unit holder's enjoyment of the property. So if you've got that safeguard, then why effectively replicate the repealed list of restrictions by not having a one-line or two-line development right? There's also going to be, as again you might expect, powers for unit holders to take enforcement action against a developer who abuses their development powers. So if they try to exercise rights which go beyond development business, or if they do exercise the rights in a way which is unreasonable, I mean, a classic one can think of is that they cut off almost all of the useful access routes to phase 1 while they're creating phase 2, then the unit holders and the commonhold association will be able to take action against the developer to put a stop to that. From a development perspective, there's also, I should mention, quite a useful provision, which is it empowers the Secretary of State to make regulations which will enable a developer to make a proactive application to the tribunal for a declaration that what they're proposing to do by way of exercising their development rights is compliant with the statutory requirements. It's similar to getting a determination from the tribunal that a large amount of service charge expenditure is within the lease and is reasonably incurred. So it will be the case, for instance, that if a developer thinks that there might be a problem with phase 1 unit holders, they can go to the tribunal and just make sure that the tribunal gives consent to what they're doing, and then they will be able to do it without interference.
I think you may have solved my drafting conundrum, but I think there is still going to be things that have to be considered in practice. How do you see this playing out for developers in practice in terms of main concerns and what they'll be thinking about?
Well, I think one of the concerns which developers will have is, as I think Anna has mentioned already, is that what they're not going to have is the right to continue to appoint and remove directors. They will lose that right once 50% of the units have been sold. So that, I think, will be a concern, despite the additional rights which they're given. On the other hand, I think the balance which the proposed legislation is trying to strike is that if the developer has flexible development rights, and they can, if they need to, get the prior consent of the tribunal, then does it actually matter whether they have an appointed director on the commonhold association? Because they'll still have the powers to do what they need to do to complete the further phases of the development. The other reason potentially for not drafting in any restrictive way is that once you have settled the development rights in the commonhold community statement, it's very difficult to vary them. That's still one of the few things where unanimity is required. So any well-advised developer is going to draft for the widest possible set of rights in the CCS.
When does control of a scheme pass from the developer to the unit holders?
50%, effectively, when 50% of the commonhold units are sold. I mean, the only thing which occurred to me, and it may be that there is something either tucked away which I haven't spotted, or that there's going to be a regulation, but as a general matter of company law, a member of a company can enter into a contract with a third party which restricts the way they cast their vote as a member of the company. So unless there's a restriction on that, I can see a developer saying, well, in the contract for sale of the commonhold unit, there's a requirement that the unit holder votes in favour of the developer. So and that's presumably something which is going to be looked at, but at the moment, I'm not sure that there is such a restriction.
And actually leads us quite neatly into looking at what kind of challenges do you think arise from having a commonhold community statement?
I suppose that it's both the benefit and the curse of this document. You have one document, and it is the document which governs everything. You don't have a series of leases. There's just one document which affects everybody. And it will contain 3 different types of provisions. It will contain the core standardized rules, which will all be prescribed by the government in regulations. Those are universal provisions, and because they're in regulations, they won't actually have to be set out on paper for any commonhold, because any commonholder in any commonhold anywhere in the country can simply look at the regulation and find out. The tricky part are the other 2 things, the local rules, because all developments are different. So an obvious thing is that the commonhold community statement for each development will have to set out voting shares. It will have to set out the percentages which unit holders have to pay into different pools of commonhold assessment. It will set out what the permitted use is of different common parts. And it will also have to set out any other specific local rules which may or may not be wanted. The things which, or 2 things which seem to excite a lot of people are, first of all, is there going to be a rule which says you can't have pets? That will be something which needs to be in the CCS if someone wants that to be a rule. And are holiday lets going to be permitted, short-term lets? That, again, is something which will have to be in the CCS if it is to be a binding provision on that particular commonhold. I mean, it's quite interesting if you think about it, because we're not going to get things like waiver. So we're not going to get a party saying, oh, well, I've been breaching my lease for 30 years and therefore the covenant is now waived, because there'll simply be one document for everyone, and it will be enforceable against everyone in the same way. So you won't get different unit holders saying, oh, well, I've got something different from what everybody's lease says.
And I think it needs a lot of upfront thinking in terms of drafting and getting the right structure in place from the outset. Is there anything else you think would be relevant to think about in practice?
Well, there are 2 views. One view is that developers need to do a lot of further work beyond what they'd have to do at the moment in setting the thing up from the beginning and making sure it's right. The counter-argument is that actually it's not very different from drafting a series of leases and head leases, because, they can in principle be varied, and sometimes the sale contract on units will allow for a certain amount of variation in the lease. But the reality is it's not that easy to change the lease structure if it turns out that the lease structure is wrong. So it's just same problem, different solution. I think the one other thing which we haven't mentioned at all, actually, and which is different, is that sometimes when developers are setting up a development at the moment, what they do is they do enter into long-term agreements with third-party suppliers, such as, for instance, a long-term agreement for a door entry system. And that agreement then passes to the new landlord, and it can continue to bind the new landlord and the leaseholders for years to come. And under the bill, there will be a provision for the commonhold association to terminate this kind of legacy long-term agreement. And so developers will have to be concerned to make sure that any long-term agreements they enter into, and which are crucial to the way the development works, are things which are going to survive scrutiny by the commonhold association when the commonhold association takes over.
And whether or not you can have a pet is one thing, but I think there needs to be some discussion around the impact that this new sort of structure will have on financial management and budgeting rules, and how that works. Have you got some thoughts on that?
Yes, it's a whole new world, really, of how this is dealt with, because it is supposed to be unit holder democracy. So the bill has a very clear and quite detailed framework as to how the budget is set, how expenditure is approved, and providing some, but crucially not very many, safeguards against unreasonable expenditure. And I think that point is crucial. It's not going to be possible for a minority unit holder simply to say, well, I know all my neighbours voted to carry out a particular repair to the building, but I don't agree with it, and I'm going to go to the tribunal and I'm going to make an application and say that this cost is not reasonably incurred. Or even worse, to make the application several years after the cost has been incurred. The idea of commonhold is that everyone will get a lot of detail. There'll be a high degree of transparency in respect of the budgeting process. They will all have the opportunity to vote. But in terms of essential repairs, for example, it will not be possible, if that is duly voted through, to go to the tribunal to challenge it. As I think we've alluded to already, there will be potentially a series of votes, because there may be a series of different costs pools, and each of those will have to have a separate budget, which is proposed by the commonhold association's directors, or potentially a section committee who are in charge of the particular section of the commonhold. And that, of course, that can, I think, in principle, be quite a complicated process on a big mixed-use development. There's another very important difference between the new commonhold regime and leasehold, which is that the bill mandates, it requires that all commonhold associations set up and maintain at least one reserve fund, so that the unit holders can collectively contribute towards this for future contributions. The idea is to avoid large, unpleasant surprise bills, for example, if the roof starts leaking. Now, again, it will be for unit holders and the directors to assess what the reserve fund should be, perhaps whether there should be multiple reserve funds and the amounts which should be contributed. But they won't have actually complete autonomy to do it, because there'll be a requirement to have what's called a reserve fund study by an appropriately qualified person, that is, an external person in effect, who will effectively tell the commonhold association how much money they should be setting aside. And in practice, this is potentially going to put costs up for good reason, because everyone should have a reserve fund. But the reality is a lot of leasehold blocks carry on for years without an adequate reserve fund, because it keeps the service charge down, and that won't be possible under commonhold, they will have to make adequate periodic payments into the reserve fund. If it all goes wrong, again, there's an improvement on leasehold because the commonhold association can raise emergency assessments. You don't have the problem which you get under modern leases, which is that the lease says that the service charge is paid by 4 equal quarterly instalments on the basis of an annual budget with a balancing payment at the end. And then when something disastrous happens, there's no contractual right to get any money. Under commonhold, if there's an emergency, then an emergency assessment can be raised.
Thanks for that. And Anna, just turning to you, are there, we've got a whole new framework and a lot of fairly complicated considerations, thoughts, structuring for developers in terms of design, structure, ultimately how they're going to market their schemes. But in terms of the practicalities of enforcement of the new regime, are there new enforcement or dispute resolution risks, do you see, in these reforms?
Well, certainly I suppose the drivers behind commonhold really are to, where possible, avoid going to court or tribunal. So to settle disputes by way of negotiation, by reaching a compromise. I mean, bearing in mind this is meant to be community owner-driven ownership of property. And one would hope that would encourage people to reach a quick and amenable resolution. In practice, I suspect it won't play out quite like that. I always sort of joke that one must never underestimate the ability of a flat owner to fall out with their neighbour. So I suspect commonhold will be no exception to that. If it is not possible to reach a compromise through negotiation, then the tribunal is really charged with the appropriate forum to enforce and find a remedy. I have separate concerns about the ability of the tribunal to deal with the uptick in applications. I mean, as you would have seen across the whole suite of reforms, it is the tribunal as the expert forum that is charged with dealing with disputes, renters' rights, obviously under LAFRA, and now, of course, under the draft bill. So there will be some clear work to be done around ensuring that the tribunal is suitably supported to deal with the influx of potential claims.
Thanks, Anna. And sorry for that.
There is a counter-argument to this, and the counter-argument is that the tribunal won't, in fact, be overwhelmed with additional work as the system beds in, because a lot of the tribunal's work is challenges to service charges, and that simply won't be possible under the commonhold system. So there won't be the need for Section 20 consultation on major works. There's no ability to challenge essential expenditure if it's been duly proposed, budgeted and voted through. There won't be any arguments that a particular form of expenditure is not covered by the lease, because it's all in the commonhold community statement, and essentially the commonhold association will be able to recover whatever money it needs for whatever functions it has to perform. And although there are rights in the bill to challenge non-essential expenditure, certainly if they're over a certain threshold, those challenges have to be brought within 1 month of the vote. So you won't get retrospective challenges, which, again, are a major part of the tribunal's workload. So, yes, the tribunal on paper has a lot of work to do. In practice, whether it will actually, and I think this is the fear, whether it will overwhelm the tribunal, who won't be given any further resources, I think that remains to be seen.
Yes, well, I hope you're right. And it's a compelling point. And I take it on board. And I suppose the other thing is that they're experts. I mean, it is a dedicated property forum. So one would hope that would alleviate some of the burden. But we shall find out, as they say.
How will the regime affect phased redevelopment or conversions? And I think that's top of lots of people's lists.
I think that one of the key policy objectives, as we know, is to ensure that current leaseholders have a viable route to commonhold. So in terms of established schemes or schemes which are underway, well, if it's in effect, if it's been built and phase 1 is a leasehold phase, then phase 1 will stay a leasehold phase unless the conversion route is deliberately taken by the fell into trap of saying unit holders by the leaseholders within that phase. So, I mean, they can, if they want, to convert to commonhold, but they don't have to. Ground rent reforms will affect existing leasehold blocks, but of course, if it's a relatively recent leasehold block, then there won't be ground rents because they'll have been caught by the ban in the 2022 Act. And I think, as Anna said, there's actually quite a significant difference between the total number of leasehold properties and those paying ground rents. And one of the reasons for that is because anyone who has extended their lease under the 1993 Act, and quite a lot of people have, then they will also have a peppercorn rent. So they probably won't be affected really by the proposed ground rent reforms. The enforcement landscape, it remains to be seen really as to whether that is going to have much effect on existing leaseholds, because the reality is that very few leases are in the end forfeit, and that they're usually where the leaseholder is entirely absent and has effectively abandoned the premises. The fact that you have a choice, I think, is quite an interesting point. It's important to emphasise this, that there's not going to be anybody who's forced to go into commonhold in an existing block. So even if leaseholders decide that they're going to exercise collective enfranchisement rights, and pausing there, they might do, because at some point the government will bring into force the change in the disqualifying non-residential area percentage. At the moment, anything over 25% non-residential disqualifies a block from collective enfranchisement. But in LAFRA, that is to be raised to 50%. So there will be, I think, quite a significant sector of blocks which are between 25 and 50% non-residential, where collective enfranchisement could be attractive. The leaseholders can exercise that right, but they will have a choice as to whether they take the further step to go to commonhold. As to phased developments, it's likely to depend, I think, on how the phasing is actually done. If the truth is that you've got a development site which is being developed in 3 completely independent phases, then it may be that phase 3, which is due to be commenced in 2035, will actually have to be commonhold, because it isn't really anything to do with the existing phases. On the other hand, if it is simply an extension of an existing phase, then it will be partly sold development, and developers will be able to continue granting long leases as they currently do.
And as Anna touched on a little bit earlier, before converting to commonhold, leaseholders have to first acquire the freehold of their building. That's through the collective enfranchisement process. I think there's a discussion to be had here around, regardless of the fact that we've got this reduction to 50% for consent, as you just mentioned, and the question arises as to whether there will in fact be an appetite for conversion, or do you think that tenants might just be happy to stop at the enfranchisement stage?
I think that probably depends on market forces, because you have to go through collective enfranchisement first, and you will have to pay exactly the same amount of money to go through collective enfranchisement and stop, or go through collective enfranchisement as a staging post to commonhold. It means inevitably that the costs of going to commonhold are additional costs. You won't have to compensate the freeholder again, but there will be significant administrative and legal costs in creating the commonhold structure and so forth. So on the face of it, there's a financial disincentive to go forward. I would have thought that the driver for conversion is likely to be the ban on new leasehold schemes, because that will mean that going forward, all the new schemes will all be commonhold. And it's the fear of a two-tier market, I think, which is likely to push existing leaseholders to convert.
A two-tier market is a fear. I think the other thing that's dawned on us all is that we could end up with a mix of commonholders and leaseholders within the same block. How do you envisage that working in practice?
Well, I mean, the bill does go into this in some detail. The freeholds of non-consenting leaseholders' flats are retained by the original freeholder, and the non-consenting leaseholders retain their leases subject to certain changes. I'm pausing there a moment. Since you have to go through collective enfranchisement first, then logically the quotes original freeholder in this circumstance is likely to be the nominee purchaser company. The leaseholders then, when they become leaseholders within the commonhold, they do end up with a rather different leasehold scheme, because the bill aligns the leases with the commonhold community statement as far as is possible to allow the block to be managed effectively. So, I mean, among other things, the leaseholder loses the right that they currently have to challenge service charges. They won't be able to go to the tribunal under Section 18. On the other hand, they gain the right to vote in the Commonhold Association when setting the budget for the charge. You could argue that they come very close to being unit holders, but without actually being the unit holder. The differences will be really quite marginal, I think, in practice, because the freeholder in most cases won't actually have a vote. The freeholder will only have a vote on some very limited issues which would affect them, such as the nuclear option of somebody saying, well, we want to terminate the commonhold so we can sell the land for development and demolish everything. Then at that point, the freeholder, for obvious reasons, does get a vote. But for most ordinary pieces of business, it will be the non-consenting leaseholder who gets to vote in the commonhold association. This dual system is clearly intended to be temporary. So the bill has mechanisms to phase out these carryover leases of non-consenting leaseholders. So leaseholders who are in what is now a commonhold development will not be able to apply to extend their lease. Instead, they will obtain the right to buy the freehold of their commonhold unit. If leaseholders want to sell, they can't simply sell their lease. They need to sell, and they will be permitted to sell the lease and the freehold, the commonhold part of the unit as a package, which means that the buyer will receive a commonhold unit.
I think, there's no perfect solution, and I don't think there is going to be a perfect solution, but there's going to need to be a lot more thought put into how best to deal with non-consenting leaseholders. Can it be right that freeholders become unit holders, given that that's not what they purchase? And in particular, how will those interests be valued when a leasehold decides to sell in the future? So there is quite a key valuation point here.
Agreed.
There is. I think it says it's not entirely clear how this mechanism is going to work, but I think the intention, as I understand it, is that when the leaseholder effectively extends into the commonhold, they will pay what they would have paid for a lease extension under LAFRA. So whatever they would have paid for a 990-year lease extension under LAFRA is what they will pay the freeholder to become a commonhold unit holder. So they should be financially neutral for both the leaseholder and the commonhold It should be financially neutral for both the leaseholder and the freeholder in the commonhold unit. But as Chrissy's rightly said, it's very easy to say, oh, you pay what you would have paid. It's quite hard actually to draft how you actually get to that result.
I think that's right. We've focused a lot just recently on mixed use, and obviously as part of mixed use we've got our commercial units. And just a moment with you, are there any specific risks that you see in terms of commercial units?
Yes, I mean, I think, as Philip alluded to earlier, it's becoming a unit owner-led development, isn't it? So to that extent, there will be becoming acquainted with new voting rights, new structures, new forms of governance, what is actually quite a complex scheme in terms of how the mechanics of a commonhold work. And also, I think fundamentally, and this has sort of a human element to it really, it's aligning sort of slightly different objectives and end goals between the residential occupants of the building and those of the developer. So there will need to be, I think, a clear sort of communication piece around any development works in that context. And also, I think a mindset shift. I mean, what we are dealing with here is completely novel. It's a radical overhaul of what many developers and commercial tenants will have understood to date. And so there is going to be a very clear communication and education piece around that as well, and how it works in practice. I think the other point to make, although we have got sections in the draft bill, which to some extent deals with some of the criticisms in terms of governance of different parts of the development, that will assist, but never forget that it's the Commonhold Association that is top of the tenure tree, and therefore has the ultimate say in how that Commonhold is run. So there will be certainly a mindset shift required for sure.
And Anna, just staying with you for a second, to wrap up our discussion sort of on the practical implications of the bill, what do you see as the biggest practical risk for developers overall?
It's going to be, there's some complex structuring required. I think encapsulating and being absolutely clear on what your objectives are at the outset. That will feed into, of course, the drafting of the CCS. I loved Philip's idea of, less is more in terms of actually simplicity is your friend. As we discovered with the 2002 Act, where you have an exhaustive list, almost to some extent you're penalising your ability to have the flexibility in the future. But if you're carrying out development business in its widest possible sense, then that gives you the flexibility. So therefore you can construe it as fit in the circumstances, arguably. There will, of course, be the upfront legal work. There's no doubt that we will and will continue to do so, work hand in hand with our clients and other stakeholders who have a vested interest in these types of schemes. And also there will be, of course, a fundamental change to the profitability model with the proposed eventual abolition of ground rent, but certainly it being phased out over the 40-year duration we've discussed. That will affect income streams. And so for those developments which factored in some form of income, obviously newer developments won't have that issue. There will be something to consider for that. And then also we have to think about lender reticence. We know that lenders have to date been extremely timid in taking on anything that is novel, particularly given the current economic headwinds that the real estate industry is facing. As we know, where there's reticence, where there's uncertainty, that leads to delay. And of course, when obviously your scheme needs to be developed quickly and built out as quickly as possible so you can realise your investment, that will have a significant potential financial implication. And also there are operational risks. Obviously, if you lose control of the development effectively by at least 50% of the units having been sold and your voting rights shift, then that will obviously better to some extent your day-to-day control. But again, to Philip's point, if actually you've got clearance to do certain things with respect to the build-out of the development in other parts, that's a different phase from the tribunal, and you are forearmed in that regard, that should reduce some of the risks. I like the novel thinking around the voting rights, but all of this is to be explored, and there will no doubt be test cases which will come to the fore in due course.
What do developers need to be doing now to address those risks?
Yes, well, I mean, fundamentally look at your tenure strategies, consider existing and upcoming pipelines, what is coming down the line. Think about your documentation. I mean, we're probably a little bit early really to do anything substantive in that regard, but start turning your attention to the potential obstacles that might be placed in your way if you have had a scheme which is based on a particular form of tenure. So to think about those, and also to think about any sort of transitional arrangements that might need to be implemented in respect of mixed use. And I think there's one point, Chrissy, I just mentioned is a consultation which is ongoing, which is on the banning of the sale of new leasehold flats, which is entitled, I think, The Journey to Commonhold, banning new leasehold flats. It ends on the 24th of April. And we would certainly encourage anybody within the sector to really take part in that and engage, so that the pragmatic as well as financial effects of this initiative can truly be communicated to the government.
And I think just to wrap up, no talk these days is complete without making reference at least to building safety and the Building Safety Act. And of course, there are many large-scale remediation projects affecting many leaseholders, which are currently underway. As Philip mentioned, there's no obligation or requirement to convert to commonhold, so there's no reason to change a tenure midway through a remediation project. There's potentially an argument, I think, that under the commonhold system, remediation may be made easier. We've got a situation where we've got unit holders with actual ownership and a say in what happens instead of having to go to a third party. And I think you touched on this in collective ownership. You've got, people are collectively incentivized, obviously to increase the value in their building, but also very much to ensure its safety. So I think there is an argument there. That said, building safety liability is something that's going to be taken on by the Commonhold Association, and ensuring that residents are capable of being able to engage with the building safety regime is going to be extremely important. Directors of the Commonhold Association will have a very key role to play in that, and potentially a significant responsibility for managing building safety. Now, there is an arguments to suggest that there will be people that don't want to assume that liability, and I think it'd be fair to say that we might see a situation whereby we get an increasing number of professional directors, and that becomes something that we see playing out a bit more in practice. And I know that you'll go on in due course to talk about it, but potentially that could play out in terms of costs of commonhold structures as well, in terms of who are paying for professional directorships to take on that liability, and I think that's something that we could well see. So the $1 million question is: commonhold the silver bullet? Is it the silver bullet to bringing the feudal leasehold system to the end, or does it simply change the packaging and not the content? Thank you for joining us today, and we hope that the discussions have been helpful. Please do look out for part 3 of our commonhold webinar series, where Anna and Philip will be discussing the pros and cons of the new commonhold regime, and we'll be looking a little bit more detail about what comes next.